My name is Jesse Schley, and I am in my third and final year at the University of Pennsylvania Law School. Today, I have the opportunity to discuss with you one of the most famous cases in Supreme Court history, Miranda v. Arizona. This case invokes both the Fifth Amendment, which provides that no person shall be compelled in any criminal case to be a witness against himself, and the Sixth Amendment, which states that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. On March 13, 1963, Ernesto Miranda was arrested in his home and brought to a police station in connection with a recent kidnapping and rape. For 2 hours, police questioned Miranda without an attorney present before obtaining his signed confession. At trial, the confession was entered into evidence over the objection of Miranda's attorney, who argued that the Fifth Amendment required police to inform Miranda of his right against self-incrimination and his right to an attorney before interrogating him. Miranda was found guilty, and his conviction was affirmed by the Arizona Supreme Court, which held that Miranda's rights were not violated because he had not requested an attorney. At the time, it was common practice for police to interrogate suspects without informing them of their constitutional rights. Indeed, Miranda was only one of 4 cases consolidated and granted certiorari by the United States Supreme Court. To say that the cases were consolidated means that because they each turned on the same issue, the court would decide them together as if they were one case. The central issue before the Supreme Court, and before you now, is whether the Fifth and Sixth Amendments require police to inform someone in custody of the right against self-incrimination and the right to defense counsel. To come to a decision in this case, it is necessary to see these rights in relation to one another and to understand how the Supreme Court, before Miranda, interpreted the right against self-incrimination after expanding the right to defense counsel. The first important case to consider is Gideon versus Wainwright. Before Gideon, the right to defense counsel meant only that a state could not keep a criminal defendant from having a lawyer at trial. However, the court in Gideon established that, under the Sixth Amendment, the government must guarantee you a lawyer in a criminal case, if you so choose, even if you cannot afford one. The next year, in 1964, the Supreme Court decided Escobedo versus Illinois. In Escobedo, the court held that the right to counsel existed not just in trial, but also when in police custody. In Escobedo, the police denied Escobedo's request to see his attorney, who was in the building, and then questioned the suspect at length about a shooting. He confessed, and his confession was used to convict him. The court overturned his conviction because, once the suspect was in custody and subject to interrogation, it did not matter that a trial had not started yet for the purposes of the Sixth Amendment. He had the right to consult with his attorney. If the right to defense counsel in a criminal case is a constitutional right, as the court in Gideon held, and because the Escobedo court determined that a person being interrogated has a right to talk to an attorney, does this mean that the Constitution requires individuals in custody to be informed of these rights before being questioned? That is the question you must decide today.